All right, we've got a telephone conference call here in Chambers. If I could have you enter your appearances, please.
This is Kathleen McConkey. This is Kathleen McConkey, Your Honor, on behalf of Michelle Wolferts, respondent.
This is Sandra Dredd, Special Master.
Jaron Bishop on behalf of Brian Wolferts.
Casey Borlick, Guardian ad litem.
All right, we've got everybody. Thank you. We had scheduled this to get the update from Ms. Borlick. Why don't you go ahead, counsel?
Yes, Your Honor. I had the opportunity to speak with my clients last night. We arranged it where they went to the church house that is near their home. They had an individual let them into what the bishopric room. They were on a private phone there. Sydney did let me know that there was another line on that phone in the church building, but she had been told that she would be left there and be left in private. I had a brief conversation with both Sydney and Danielle to explain what had been going on in the court system and to explain what we were there to talk about and to let them know that I wanted to hear how they were doing and anything that they would like the court to know. I indicated to them that I would be their voice and that I would let the court know exactly what they wanted the court to know. I spoke initially with Sydney, and the first thing that she said to me was that she wanted very much to tell me how she was truly feeling. She was very concerned that there would be negative repercussions for her having talked to me.
Now, let me interrupt you for just one moment. Will you remind me the age of Sydney and Danielle?
Yes. Sydney is 16, and Danielle is 15.
15?
Uh-huh.
Okay, thank you. I apologize. Go ahead, counsel.
Okay. She stated, again, the first thing she said to me was she really wanted to tell me how she was truly feeling, that she was concerned about the negative repercussions for her having talked to me. These are word for word. She said, in fact, she was counting on it. She was so very concerned about what would happen to her for talking to me, but what she kept saying to me was that she so wanted truth that she was willing to risk the negative consequences. She was concerned about all the people in her life be offended or upset if she were to tell how she truly felt. She wanted to express how she felt, but she would.
Excuse me, Casey. Could you speak up? I'm having trouble hearing. I'm sorry,
Okay.
There's something I think maybe with our phones, but could you speak right into the phone so I could hear properly? Thanks.
Sure. Is that any better or no?
That is better. Thanks.
Okay. All right. She was very concerned about the people in her life that would be offended or upset because of the things that she needed to tell me. She was told. She's told me that people had been talking very poorly about me as her attorney, telling her that she shouldn't talk to me. They told her that she shouldn't talk to me because I was aligned with her mother. They told her that she should not agree to an evaluation, and she should not be talking about talking with the evaluator about the things that were going on in her life or how she really felt. She has not been met with or talked with separately or independently of her father at any time since Slate Canyon. Nobody has talked to her independently to see how she was doing, see if things were okay. She has had all of her social media access restricted. She's only been allowed on the school website and the school email. She has no idea what is going on in the courts or anywhere else. She was shown a copy of the original ex parte order. She was then never told about the new order or what had happened in court 2 weeks ago. She had no idea that she could have any contact with her mom. She was told that nothing could override the High Road to Reunification program and what they were telling her. She believed that the 90-day no contact order with her mom was still in place. She then told me the story of her transfer from the very beginning, and I'm only giving this to you for a purpose. Again, she told me that they came to her very early in the morning, that they were very confused and disoriented. She said that she wasn't okay or that she wasn't ready. They said that that wasn't okay, that they had to go. She struggled a little bit and was rough-handled because of it. She said she was extremely stressed. They took her to a hotel to meet with some people. She thought that it was going to be therapists that she was going to talk to in order to transition back to her dad's home, because that's what we had discussed before. It was the possibility of what was to happen. She said she was extremely traumatized. They thought that she was really scared because of alienation, but I did not feel that way at all. I had not talked to anyone that was not biased about her situation. Okay, so that's where she started this conversation. Then she wanted to let me know how she was doing now. She says that she's doing very well in school. She's working very hard and doing the best that she can there. She says that things are going well in her dad's home. She stated that what she wanted the court and everybody to know the very most of anything was that she loves her dad, she loves her mother, she loves her stepmother, she loves her sisters, she loves her little sister Abby. She loves all of them, and she does not want to upset or offend them by telling what she really feels, but that she needs to be heard, and she wants her voice to be heard. She feels it is very important that she have an evaluation. She told me countless times how much she was looking forward to having the evaluation so that the truth could be found. She told me that they had told her that she was so alienated that she did not know what she was saying. She wants the truth to be known. That's it, period. She wants an evaluation. She kept saying, I want an evaluation by an extremely neutral, extremely credible, extremely professional individual so that the truth can be known. She wants every single test they could possibly give her. She wants to take a polygraph so everybody can know the truth. Then she talked to me about the fact that she believed that if people really wanted the truth and they really wanted to know the full picture, that they would have evaluations for everybody involved. Mom, Dad, Danny. So again, if they were really interested in finding the truth and finding out what is best for their future, that they would have everybody involved take an evaluation. She wants an evaluation. She believes that it is important for her to be outside of her father's home so that she is not influenced, so that she's in a neutral environment, so that she can feel that she can openly and honestly discuss the things that she needs to do without having negative repercussions. And again, she's counting on repercussions, but was willing to take the risk because of her need to have her voice heard and to have the truth come out.
Wow. Wow. I talked with her about the possibilities of the placement. She was very, very, very concerned with the issue of neutrality. She wasn't sure that anybody could be neutral under the circumstances. She said, I don't know if anyone anywhere can be neutral. I talked with her about the things that I had learned in my interviews. We discussed the options. She felt that the Haddocks were a good place for her to be. She felt that everything that she knew about them made her feel that she could trust them and that they could be neutral under the circumstances. And that was her big thing. She needed neutrality. She needs to know that she is in an environment where she can do what is needed under the circumstances to tell what needs to be told. I also had an opportunity to talk with Danielle. She said to me that it was important that she be outside of her father's home, that she agreed to the Haddock providing that placement. She indicated that things were going better at her father's home than before they left, but that she wanted to be outside of the father's home. Your Honor, Sydney, it was a hard conversation. She feels that nobody has done anything to hear what she really needs them to know. She has been left in the dark. She hasn't been told anything, and that was very, very concerning to her. Your Honor, based upon that interview, and again, she loves her family, and she wanted me to express that in any way that I could to the court. She loves them. She does not want to feel caught in the middle. She wants to be able to express how she feels. She wants the truth to be out there. She wants the evaluation to happen as soon as possible. That she's very concerned about her education, but said that if they needed that this evaluation was the most important thing in their lives to figure out where they go from here in the most appropriate way and in the way that is best in their best interest and will help them have future successes, Your Honor. So based upon that is my recommendation that the children be immediately transitioned out of the father's home for the period of time that an evaluation is completed and until the professionals working with the girls recommend their transition back into the father's home.
All right, thank you. Let me turn to the special master and see if there's any input from Ms. Dredge.
Your Honor, so this is Sandra. I had felt from the very beginning when I understood these children were going back, and I've expressed it, I believe I expressed it to the guardian ad litem, and I believe I expressed it to Michelle Jones, that I thought these children need to be in a neutral place till the reintroduction could be handled and the testing could occur. I totally support the guardian ad litem in that, and I'll do anything I can that the court requests to assist her in making that happen.
Thank you, counsel. I appreciate that. Let me hear from Mr. Bishop.
Your Honor, I disagree. My client would disagree. The problem I'm again having is I'm lacking a statutory basis for the request for the removal. I get that's what the girls want, but the court isn't set up and the legislature didn't set this up to do what girls or kids or teenagers want. There are constitutional rights in place here, and there's zero statutory basis. The girls' comments sound like kids that have been alienated. That's the whole alienation. The whole alienation is if they accept the parent, to them, they're rejecting their mother by not hating their father. I feel like they're stuck in a place where they have to do this or feel like they have to say it to make sure their mother doesn't hate them. Their mother concealed their whereabouts. I mean, this is classic parental alienation, and I don't think we should feed into it. And I'm still lacking from Ms. Borlick a statutory basis for the removal. When I talked to Ms. Borlick at mediation, I said, look, I hear what the girls are saying, I understand it, but you and I both know, and she agreed, that based on the allegations that were made, the juvenile court wouldn't do anything. They wouldn't remove the kids because there's very strict rules and guidelines set in place by the legislature for removal of children. It's a constitutional right that he has as the father to not have his children removed unless there's immediate threat of physical harm or sexual abuse. And neither of those have been found, and there's just nothing supported it. There's been 3 abuse petitions filed this year, and all 3 have been dismissed. And so I'm a little frustrated that, and I understand Casey feels that she's representing and giving the girls a voice, but she also has statutory duties to uphold the Constitution, and that is just being thrown by the wayside here. I don't see a justifiable constitutional basis for this removal. I don't see why, if therapy and the purpose is reunification, why that can't be done with the girls in their home. And I think constitutionally, my client has a right to have them in their home, in his home.
Thank you. Ms. McConkey.
Yes, Your Honor. I think the court needs to remember that the girls have never been heard. The only time the girls have been heard have been through Miss Borlick, and they've never, and none of these issues have never been adjudicated in the juvenile court. Never. And I think if the court, I did have a chance to receive the journals from my client, and I think if the court had an opportunity to review the journals, a lot of what is said in those journals is very sad and almost horrifying. And so what you have here is you do have a statutory basis, Your Honor. I mean, we have filed a There's a petition to modify the decree in your court. We have filed a counter petition, which has brought all of these issues before your court. So you have the jurisdiction. The jurisdiction remains in the state of Utah. And the court has a balancing test, and the balancing test is the constitutional rights of a parent versus the safety of the children. And at this point, I think we have the safety of the children, because it's not as if the court can't place the children back with the father if after the evaluations and after a period of time. But we have never had these kids evaluated. They have never had anybody except Casey that they've been able to talk to. The court has these issues before Your Honor. You're the court of the original jurisdiction, and you've maintained that jurisdiction. And the court has the best interest of the girls as the top priority. And in terms of, it's so interesting because the girls have always claimed abuse. In fact, they ran away after they'd been living with their father, and their mother had not had an opportunity to, if they'd been happy with their father, why would they have run away at the thought of going home? They ran away before they were allowed to be returned. And if you read the journals, you can see that the girls are angry with their mother for insisting that they need to go home, because that was the order of the court. And so we need to sort it through, Your Honor, and we need to get those girls out of his home. You can see from what they even told Casey, and they were feeling uncomfortable about talking to her at all, that it was a terrible transfer, that they felt afraid and they were roughed up somewhat, and that they were, and that they were told things that weren't true. They weren't given all the facts. They were told that they couldn't talk to their mother for 90 days. So, Your Honor, I think you can see that there, Mr. Bishop's client comes to court with unclean hands. He didn't, when we went to court before, we had an idea of what the court intended. And this was not what the court intended. The court intended that they not continue on with this reunification type of stuff, and that we would have a chance to have my client have contact with the girls. And none of that has happened in 6 weeks. And during that 6 weeks, they have used that time to try to convince the girls that how they feel is not important, or is not right, or is not true. And I'm afraid we're going to have girls that will have real mental issues in the end, unless we can get them out of there, give them a chance to talk, get the evaluator to give us a report, to give a report to the court, and then we can see where we are. But right now, I think it's really important that we get the girls removed, and I would like them, if the court will order it, removed today.
Cite to me the statutory section that would allow me to do that.
Well, Your Honor, the court has the right to make. We've asked for a change in custody, yes. And if the court feels we've asked for a change in custody because of all the things that have gone on, we have a counter petition before the court.
Yes, I know.
And the court has the right on a temporary basis, for the best interest of the girls, to make changes, to do exactly what we're asking the court to do.
Cite to me the statutory section. And right now, father is the custodial parent.
Right.
Are you asking for me to... Let me finish my question. Are you asking me to restore custody to mother? Is that what you're asking?
I'm so sorry. I'm sorry, Your Honor, you're breaking up. I'm having a hard time. Could you...
And I can't hear either. This is Sandra.
Are you asking me to restore custody to mother today? Is that what you're asking?
No. What I'm asking, Your Honor, is I'm asking that until we can sort this through, the court has the right to... The court has the duty to put the best interest of the children above either interest of these parties, whether he has a constitutional right or not. My client, even though she's not the custodial parent, Your Honor, she has a constitutional right to contact for these kids.
I understand that, but this is not a juvenile court. I don't have a petition from any child welfare agency asking for me to put these children in foster care. I have two parents who are fighting for custody. Right now, Dad is custodial parent. Cite to me the section that tells me that I can take these children away from both parents and put them in another home.
Well, I guess the only thing I can think of is that by common law, certainly, and by statute, if that's in the best interest of the children, you have the right to make those types of decisions on a temporary basis. You've got to remember, Your Honor, this isn't a permanent order. This isn't a permanent order.
No, it's not.
And certainly,
cite to me the statute that tells me that I can, in a parent's dispute about custody, that I can put these children in essentially foster care. Tell me where I have that authority.
Well, I would just suggest that I think that the court has that much discretion to be able to do that because of the best interest standard. That's the only thing I can think of. I can't think of a statute that says that specifically that the court can take the children from both parents. But I've been involved with doing this for a long time, and there have been cases, Your Honor, where the court has given the children to a grandparent when both parents are fighting over the children and neither are capable or competent to take care of them. I mean, that's happened. I'm sure many of you have seen that happen in district court. And the court does it on a temporary basis, and then we work out the final issues of whether the grandparent will intervene or not or whatever. But I think, Your Honor, under these circumstances, what else is there to do? Put the children back into the care of a home when the children say, "I know I'm going to have repercussions"? What can the court do? What else can they do? And I think we could get the evaluation done on a very quick basis, I would think.
Thank you.
Your Honor,
Bishop, go ahead.
Yeah, you're right. There is no statutory provision that says you can. There are multiple statutory provisions that say you cannot. 62A 4A 201 states very clearly that the state has already determined best interest. It is in the best interest and welfare of a child to be raised under the care and supervision of the child's natural parents. A child's need for a normal life in a permanent home and for a positive, nurturing family relationship is best met by the child's natural parents. The right of a fit, competent parent to raise the parent's child without undue government interference is a fundamental liberty interest and has long been protected by the law and Constitution and is fundamental public policy of the state. The state's already determined best interest. The only way to remove a child is under the Juvenile Court Act, which states immediate threat of physical violence or harm or sexual abuse. Those are the only two scenarios. Ms. Borlick knows this well. This is what she does. Yet she's still recommending their removal. Again, I've asked for a statutory provision that allows the state to do this, and there isn't one. Yet they keep asking for it. My client has a constitutional right to do this. The court cannot do this on a temporary basis. Rule 106 states the order remains in place during a modification until it's been modified, unless there's immediate and irreparable harm. That hasn't even been alleged, and that's not even before the court. But there's no immediate irreparable harm. And that would be a change of custody, which would mean that the children have to go back to their mother, which clearly isn't going to happen. The state, and what everybody's asking, is removal from a child's parent. That is a constitutional right, and the state has a compelling interest not to do that. That is strict scrutiny. That is the highest level of constitutional protection, and there is simply no justifiable constitutional basis for their removal. And that's what I have a problem with. There have been multiple petitions, abuse petitions filed. Ms. Borlick is not the only one that's met with these girls. Ms. Conklin wasn't part of the juvenile court proceedings. DCFS did an investigation, and they closed their case without the request to remove the children. Kansas has done an investigation and has closed the case without the request to remove the children. There has been no request to remove the children. And so we can do an evaluation, we can do all these things, but it should not include the removal without a statutory basis.
Your Honor, the court has, we're basically telling the court we think there is irreparable harm. And that there's no way for the court to be able, there's no way for an evaluation to take place when the children are not in a neutral location. And the children were at Canyon Slate for a long time. You know, it's all right to put them for temporary periods of time into a situation which will protect them. And we're saying that's what we're saying. We're saying there's going to be irreparable harm. And how can we get an evaluation of that's genuine unless we have them removed, Your Honor? We have to have them removed to get the evaluation. We can't, the court has a duty not to place these kids back into a situation where they feel that there'll be repercussions, and we don't even know what that means, that they're going to be hurt.
There's no history of any physical violence to these kids. To say that they're going to be hurt is just another indication that they've been coached.
That's not true.
There's zero evidence of any physical violence. I've read every single abuse petition that's been filed. There has been zero.
That's not true. I know that the adult daughter who lived there said that she had been hit and shaken and slapped, and her skin had been pinched.
They alleged that Abby had been alleged, and that's
no. They alleged that Abby had done it, but she also alleged that he had physically hurt her. Look at her declaration.
Well, I don't. We're not here to resolve anything with the adult child. We've got Sydney and Danielle. I don't want to drag the other kids into this. We're not addressing those issues today.
Well, the only reason I brought it up, Your Honor, is because he claims there's never been any physical abuse, and we have a declaration saying at least with one child, when she was in the home, she suffered physical abuse.
But we're not talking about that child today. We're talking about Sydney and Danielle. As I understand it, I don't have any allegations of physical abuse with respect to Sydney and Danielle, correct?
That's correct.
I'm not sure. I had thought that there had been allegations of physical abuse with Sydney and Danielle.
There's been zero, and I've read every abuse petition.
At our last hearing, I was told by Ms. Borlek that the allegation with respect to Sydney and Danielle was emotional abuse. I have no allegations of physical abuse with these two girls.
I know that in one of the declarations of of Brittany, the older sister, she said that she witnessed Brian knocking the air with, I think it's the elbow, I have to find it, with his elbow knocking the air out of Sydney. I know that there's at least that, and I can find it for the court, and if the court wants, I can get it over to the court.
Well, that sounds like it could be just as much accidental as anything. I'm really interested in something that's more substantiated than that.
But what about, Your Honor, the fact that they had in their journals that he was bringing them into their room and forcing them to stand there when he was not dressed, when he was fully exposing his genitals?
Physical abuse is not the only harm the court should be concerned with. And when talking to Mr. Bishop about this issue, I was merely talking about my experience with Utah DCFS. And I will note that, again, as indicated in the reports of the court and DCFS, one of the main reasons why they did not remove was because there was this plan in place in which the girls had another means of being protected.
A plan
and
which,
they're not
again, Ms. Warwick hadn't seen. And again, we're skirting the issue of, is there an allegation of physical abuse, and is there a statutory provision? And no one can give you an answer, or the judge can.
I'm not saying there is physical abuse. All of the claims that Sydney and Danielle reported to me were absolutely emotional abuse and sexual abuse in nature. And I'm saying to the court that the court can make findings or the court can make these calls regarding the best interest of the children. There's ample case law to support the fact that if the children are in irreparable danger of being harmed emotionally, is one of those things that the court can consider, and that is the case. Your Honor, the court here in Heber is waiting for me to come in. I believe that I have been heard. I've given the court a report as to what the girls reported and what I recommend. I'm asking that I be excused at this time.
Do you have anything else to add quickly before you go, Ms. Borlick?
I don't believe so. I think that I have expressed what needs to be expressed. The only thing that I would like to add is that Mr. Bishop has made the motion to have me removed from the case or dismissed. I would ask that the court make the determination, first of all, whether the parents are impecunious, so whether or not a private guardian ad litem or a public guardian ad litem would be appointed. And then it's going to take me hours and hours to respond to an absolute attack on me. And this isn't about me, but if that needs to be done, I will take the hours and take the taxpayers' money in order to defend a position that must be defended in the best interest of the girls. But again, I would just ask that I be given that the court make the findings of impecuniosity or not prior to my having to answer to the request to have me dismissed, because I was never appointed on this case in the first place. So I think that it would not be even a question right for the court.
I know I do have an affidavit and declaration filed in support of respondent's request to appoint the jail in this case, and I'll take some time to review that affidavit so I can make findings with respect to the impecuniosity.
Okay.
I can't do that at this moment. I know that you're in a hurry, so I'll let you go, but I will make those findings, and we'll see where we are.
Okay, and does the court give me leave them to not respond to the motion to dismiss me, as that question is not even right if I haven't been appointed until after the court makes that decision?
I will, yes. Don't worry about responding to that until I have a chance to look through Ms. McConkey's affidavit.
Okay, all right. Thank you, Your Honor. I so appreciate the opportunity for the girls to have their voice heard.
I appreciate you very much taking the time last night to talk to them. Thank you very much.
You bet. All right. Good luck to the parties.
Thank you.
Thank you. Thanks, Casey.
All right. We've excused Ms. Borlick. Then I think we still have the guardian. Have the special master. Let me ask Ms. Dredge. I do have some concerns about the request that Ms. Wolferts is making. I certainly share their concern about the best interests of these children. I want these children to be protected and have the chance to have an evaluation done in a neutral way. I don't want the reunification with their dad to be something that is pressured. This should be done in a professional way. Now, keeping that in mind, I'm concerned that what Ms. Wolferts is asking me to do is something that would be more appropriately done in a juvenile court setting, asking me to place the children essentially in foster care. This is a divorce court. I have competing petitions for custody of these children. Father is custodial parent right now. I'm frankly not interested in this telephone conference in changing custody to mother. Mother does not have clean hands. I'm interested in restoring custody with father and getting this reunification done. I'm certainly happy to entertain the petition that's been filed by mother, but right now the issue is how we're going to manage this reunification treatment. Wait. I'm asking a question of Ms. Dredge. Does the special master have any position about the statutory authority of this court to do what Ms. Wolferts is asking me to do?
Your Honor, I haven't studied that in depth at all. That's in my role. I do have, and this may be totally off the page, all right? I admit that. But couldn't these two parents agree? Couldn't Dad and Mom stipulate that for a period of time, these girls would be in a neutral setting, get the evaluation done, and have it be based on their agreement and their stipulation, get it done, and then have to address, have issues or come up as a result of that then either the court would have to address in terms of immediate and irreparable harm or not. But couldn't both these parents be in a position where they can look at this and make an agreement and move forward that would help these girls and do it together and present that kind of affront to these children?
I think that's a wonderful idea.
Certainly, I think that's what would be the best thing, Your Honor. But it sounds we clearly would like to make that kind of an agreement, but it sounds as if Mr. Bishop is clearly opposed to allowing that to happen.
Mr. Bishop?
My client is not going to agree to the removal of the children from his home. They've been gone for 18 months. The concern now as well is he is continually getting bombarded with these allegations that he's this abuser, that he's a molester. I mean, and these are coming from Mom, they're coming from Brittany, and they're unfounded and have been continually unfounded. And so, this idea that we can just all come together and sit down at the table and do what's best for the children, simply, I don't know. It's going to take time to get back to that point, and a lot of things have to change. We can't just ignore the last 2 years. Clearly, Mom has zero interest in Dad being in the picture. That's evident. And
yeah, that's not true.
Any efforts that she's going to make, she wants the kids out of his home because then they can further perpetuate the ideas that Dad's an abuser. Miss Borlick stated the girls said they're doing well in his home.
She did.
She said they were doing better. They're doing better, but not.
They're not being abused. They're not being harmed. I think
Your Honor,
as
Ms. Borlick was talking, she said, Sydney said, and I wrote it down word for word, things are going well at Dad's home. That's what Sydney said.
And so I'm saying I have no problem with the evaluation and getting them reunification therapy, but I get the impression that, and to give a little bit of history, Miss Borlick from day one has been requesting the girls be removed from Dad's home. From day one, she wanted the girls to stay in Utah. It just simply made it impossible for reunification. I think we're missing that. We're trying to reunify the relationship with Dad and the girls, and by removing them or trying to get them out, I get the impression that they're trying to get them out so that they can perpetuate or find ways to accuse my client of being an abuser so they don't have to be back with him. The purpose of this is to reunify. They have been in his home for 6 weeks now. They've been doing well. All reports from the High Road reunification therapy said that they were going well. If the girls need a private therapist to talk to, that's great. Let's do that. Let's get them the help. But let's not forget the idea is reunify the kids with their custodial parent, because that relationship's been lost. When the girls were in Kansas prior to the summer of 2014, they were doing well. They had a therapist there. There were no allegations or discussions of abuse or anything. And even today there aren't. And so I think what we need to be focusing on is getting the family the help, and that's what Family Preservation said. That's what their plan said, is to help unify this family. They didn't recommend removal. I submitted that document. They didn't recommend removal. Let's get them therapy. Let's get them evaluated. Let's see what we need. But I think we've got to follow the Constitution. And sure, the court has discretion. The court has equity, but those are within the bounds of the law. And the legislature's already dictated what's in the best interest of these kids.
Your Honor, if I may, what the court needs to remember is the fact that we've never even had them evaluated as to whether they were alienated. And so the reason why they need to be out of the home is to make an evaluation to find out if in fact there has been abuse. The court certainly doesn't want to send these kids back to a home where there has been abuse. And so we need to have them in a neutral place. It doesn't have to necessarily be for a long time. Certainly it would be a small disruption. And that's what the girls want. That's what the girls want. They want to be, and they said that they loved their both parents, their father and their mother, but they want to have a chance to really tell their story, and they don't feel like they can tell their story in the home. And I think that what we really need, and I think that what Casey's been trying to do all along, is that she wanted them away from Dad so that she could really figure out, get them evaluated, keep them here, have them evaluated, find out if all of these things have been going on that they are claiming, to put them back into the home of the abuser. How are they going to, if that in fact is the case? Let's find out. Let's take them and put them into a place where they have the safety that they need to tell their story. And Your Honor, we haven't gotten to this point yet, but we do want to have an evaluation, a custody evaluation, And, that could be something in addition. So the court, these issues, the court does have the discretion to place the children for short periods of time, and it doesn't have to be a long period of time for an evaluation purpose. I'm just really worried that the evaluation is going to be useless unless it's from a neutral location, and it's going to be expensive for my client, and she's willing to do it. And my client, none of the evidence is my client took off with the kids for 18 months. She knows that was wrong. She knows she shouldn't have done that. She felt trapped. She didn't know what to do. But there is no evidence, not from the girls, not from any source, that she ever has alienated these girls, ever said anything except good things about him. There's no evidence at all that she has ever, in fact, the only evidence from the girls is that the dad was always saying bad things about the mom, or you're never going to see your mom again. There's no evidence to that. There just isn't.
This court made judicial findings of that already.
There's no evidence to that. There's no evidence. I've not heard this court. Well, I've just not heard that. And, Your Honor, the only evidence that the girls told Miss Borlick was that the mother never did those things. There's absolutely no evidence of any of this stuff or bad faith. My client freely admits that she made bad decisions, in the end she thinks she hurt the girls. She knows that. And she doesn't know what she needs to do to try to get back to square one. But she does know that she's really worried that why would her girls run away unless they were really, why would they go through that? I mean, we have 2 teenage girls that ran away. They're old enough for the court to listen to what they have to say. We need to hear them. And I don't think you can hear them if they're not in a neutral location. For a short period of time, I mean, the court has ordered kids to go into various programs, rehab programs, other things for short periods of time. The court can do this. It has the discretion to do this. And we're not asking for a change of custody. We're just asking that the court has authority over the children. The court has jurisdiction over the children. The court has jurisdiction over the parties. And courts do this all the time. And we really just want, for a short period of time, Ms. Borlick says there was a plan, and the plan was never to return the children directly to the father. And look what's happened. They do a ex parte order, and they do all of these things, so the children now have been in the father's home for 6 weeks. And that was never the plan. At least that's what Ms. Borlick has said. Ms. Borlick said there was a plan. They were not to be returned to the father. And now they're in the father's home.
Thank you.
I
appreciate the feedback of everyone involved. I recognize, again, that this is something that's very emotional to the parties. I have concerns about the welfare of these girls. I want to make sure that they are taken care of. I want to make sure that they are able to have a healthy relationship with both of their parents. I want to make sure that we thoroughly explore their condition, and if what they want is a neutral evaluation to get to the truth, then I hardly agree that needs to happen. Now, that being said, the role of this court is to place children with parents. I am not a juvenile court that puts kids in foster care because of some sort of petition from DCFS. I am here to make decisions about custody between parents. Right now, father, and I appreciate that that's aggravating, counsel, but at this point, no one has cited to me any statutory authority for me to remove children from father's care. And that's what you're asking me to do. You are asking me to remove children from the home. This is not a juvenile court. Father is the custodial parent. Now, what I can do is place conditions on father's custody, and I'm prepared to do that in order to protect these girls and make sure that we get things in place for their best interest. So the order is the children are going to be evaluated by a neutral person, and this is going to be someone who specializes with reunification. The evaluation, the meetings, testing, therapy, anything of that nature, I want to take place at the Haddocks. I want the children to be able to leave dad's home, go to the Haddocks, meet with their therapist, feel like they're in a safe and neutral environment where they can fully discuss and disclose everything that they want to talk about. But father has custody. He's had custody now for 6 weeks. The statement we have through the guardian is that things are going well at Dad's home. I see no reason to remove children from Dad's home if Sydney herself is saying that things are going well there. She's saying that things are going well in school. It appears that they have been able to transition themselves back into their old environment quite well. And I'm very pleased to hear that. I want these girls to do well. They can continue with their current placement, having neutral, safe places where they can meet their therapist and have this evaluation done. And as a further condition, Dad is going to have an evaluation and therapy as well. I want parent classes, an evaluation for him to make sure that he's doing what he needs to do to reunify the children, make them feel like they're in a safe place as well. And this can, I'm certainly open to suggestions about whether this should be the same therapist or a different therapist, but there needs to be somebody who specializes with these types of reunification issues meet with Dad so that he can be sensitive to the feelings that the girls have and what they need to make them feel safe and feel like they are being respected, and that the particular difficulties in coming home after such a long period of separation is something that he can be attuned to, and I think that will satisfy the concerns to make sure that this is a safe place for the girls.
Okay.
Your Honor, would you like me to prepare the order?
Yes, that's fine. I'll have Mr. Bishop prepare the order. We need to make sure that we can get an agreement on who the therapists are going to be.
And we can't just let it go another 6 weeks, Your Honor. I mean, we've got to do something quickly.
We're going to take care of that right now. Now, we talked about some names yesterday. There was, we talked about Ms. Money, I think, had been one person that we talked about in who was specializing in this type of therapy.
Yes, that was the therapist I had, and I'm happy to go with the therapist if that's what Ms. Borlick would like.
Your Honor, this is Jen. May
Yes.
I address that for a minute?
Please.
I know Ms. Wolferts, I certainly think she's got the appropriate skills. I do have a concern that if we go with Miss Money, she's got to get to Kansas, or these girls have got to get back to Utah. And I'm not sure, talking about this one-time, short-term, kind of sit down and take a test and walk away. I'd be more supportive of someone that's closer in the location and that then knows the credentials and the expertise of the people in that area. This is going to be an ongoing issue in terms of finding therapists that can work with these girls and or Dad if that's necessary. And boy, I just think a local expert would be more appropriate and probably more helpful.
So what if we allowed Miss Money to choose or investigate or find someone in the area? That way it's coming from a neutral party that's not invested.
Your Honor, I just hate to have, ask someone else to do something. I just want to try to get the therapist in place. Why not have Ms. Borlick call Dr. Lassen and see if they feel comfortable with him? He's from the university there. Everyone said he's very well thought of, and or we could provide another name, but we just really wanted to start immediately so that there's no, there's been a 6-week delay already.
Well, my thought was my problem with Mr. Lassen was he had zero experience on his resume with reunification. If this is what Miss Money does, why don't we let her refer us to someone in Kansas? She can look at the credentials and she can make a recommendation.
I believe Dr. Lassen does reunification as well. I mean, I think, why don't we talk and find out if you feel comfortable with him? I mean, he's agreed to do it if he's appointed. I mean, we could start looking for other people. The court asked me to try to find someone because my client was the one who was paying for it. We spent a fair amount of time calling around and talking to people. That's the name we came up with.
I'm going to ask Ms. Dredge, the special master. She is a neutral person involved with assisting both parties. I'm going to assign Ms. Dredge with finding a therapist. I concur with Ms. Dredge that someone local out there is going to help not only save costs for Ms. Wolferts, but I think we'll be able to help in something that's more ongoing. If we send Ms. Money out there, then that probably is going to turn into more of a temporary type thing, and I would like someone local who's able to be with the girls as often as needs to be there.
I agree with that. I think that makes sense.
I agree with that as well.
Just so I'm clear, because I was out of this loop for a bit. Are we looking for two people? Are you looking for someone to do an evaluation to determine if there's been alienation, and if so, what steps need to be taken to allow for the reunification, and then determine what specific therapy is needed, and then to find the therapist that can provide that therapy? Or are you talking about one person to do both?
I understood, Your Honor, that we were talking about someone who had reunification experience, who could do an evaluation as to whether there has been alienation, or whether the girls actually have had an abusive relationship. We're interested in finding out from them whether there has been an abusive relationship, I would think, and that could continue, with some sort of therapy. I was hoping we could just use one person. The expenses start to really, get high for my client. She's not working right now.
I think that one person who could cover all those bases would be best. I want to explore if there's been emotional abuse. There's certainly allegations that there's been emotional abuse from Dad. I want that investigated. And then, of course, there's the issue of alienation, where Mother has been with the girls for 18 months, hasn't allowed contact with Dad. I think that obviously parental alienation is a big issue that needs to be looked at as well.
All right. I'll do my best on that. All right.
And I know that's a big order, and so I appreciate very much, Ms. Dredge, your willingness to jump in and find someone who can be neutral. That's important to me, because I think it's quite clear that the girls feel really pulled between both of their parents, and I wish that Mother and Father could work better together for the sake of their children, so that the kids don't feel that way, but obviously that's how they feel. So I think that the evaluator needs to be neutral, and I feel more comfortable in having Ms. Dredge select that person so that it does come in a neutral way. I think that Dad's therapist probably should be a different person, so that they each have someone who's looking out for them in their own therapy needs. So if you could also find a therapist for Dad to do sit down and talk with him and educate him about the parental alienation, and if there's parenting classes, I think a broad kind of evaluation is probably the word I'm looking for, is what needs to, where we need to start with Dad so that we can see what his needs are and what kind of therapy might be good for him as an ongoing thing.
Your Honor, are you saying to me that as the special master, I'm to get a therapist and put that in place, or am I to make recommendations to the court and to the council and their parties?
I would like you to find those two names, give those names to Mr. Bishop. He's drawing up the order, and he's going to put those two names in the order.
And And then Mr. Bishop and I can maybe come to an agreement with the special master.
Okay, I'm about to get on an airplane, and I won't be back in Utah until next Tuesday. I do have some contacts, and I will do this as best I can from out of the state, but it may not be as fast as if I were going to be here. But we will do our very best to do this as fast as we can. I have a question.
Okay.
I really would like the court to address, and I think it's the same one that Ms. Borlick raised. Is she going to remain or be appointed to continue as the guardian ad litem? As the special master, and I know this isn't before the court, okay, Ms. Wolferts hasn't paid me in ages, and Mr. Wolferts has indicated that he doesn't feel like he ought to have to pay anything that is a result of the fact that Ms. Wolferts and the children disappeared. So any help that I can get from the guardian ad litem, just going forward, I think would be very beneficial.
Go ahead, Ms. McConaughey.
Yeah, we're fine with making sure that whatever her bills have been, we'll certainly do what we can to pay those if we owe her anything. But I think that I think it sounds like it was Mr. Wolfert who owes her. But I would certainly be willing to do that if
hasn't paid in years. All right. So I'll do the work. All right. I'll spend. But
the other thing.
I may need some help, and it may be that Ms. Borley could provide some assistance going forward. And I think she'd be a valuable asset here.
Oh, shoot. The other thing, Your Honor, could we put into place that the parties will be enjoined from trying to discuss with the children what happens in the evaluation? I mean, I'm worried that the petitioner will attempt to pressure the girls into telling him what's happening and what questions they've been asked, and I think that would really be a disaster. So I think that we should have an injunction in place that neither party, neither the mother nor the father, try to get the girls to discuss with them what's happening or what they're saying to the therapist, because the girls need to feel that there's some leisure that they can do that without repercussions.
Agreed. I'll have Mr. Bishop include that in the order as well.
That
goes to both parties. Neither of them are to speak with the girls about what occurs during therapy. Which brings me to my next point. Ms. Wolferts does have rights to talk to the girls. It does have to, as I mentioned previously, be supervised, but she does have a right to have the supervised conversations with the girls. Do we need to schedule something so that can take place?
Yes, Your Honor. We could use the haddocks for that as well. The girls could go over to the haddocks at certain times after school and have discussions with their mother. It just needs to be without having the father there.
Are the haddocks trained? Do they have? Here locally, ACAFS trains people to be supervisors in that kind of situation. Are the haddocks certified to do that sort of thing?
I know that Ms. Borlick had them. I know that they have been somewhat involved with DCFS in Kansas. That's how Ms. Borlick, I believe, she received their name. I think that's my understanding.
My understanding was that Ms. Wolferts was to find a place out there to help with the supervision. She hasn't done that yet. But I would request, I think the original order was professional supervision with someone trained.
Although
I'm
Ms. Borlick,
happy
I think,
to entertain if Ms. Wolferts is suggesting the haddocks serve as supervisors, I'll approve that as long as they are trained to do it. I imagine Kansas has something similar to what we do with ACAFS, and if they can get the training to be supervisors, then I think that works well.
Yeah, I think so as well. I will
supervised or trained as well.
Okay, and then, Your Honor, if in fact they are not trained, can we figure out how to have some immediate contact with the girls?
If haddocks aren't trained, then you'll need to find something like ACAFS out there.
Okay. And we can do that immediately and set it up, and we can get it set up so that she can talk to them this week.
Yes.
Okay. Thank you, Your Honor.
All right, so do we need to... I will quickly look over at the request with respect to the guardian. Gosh, there's a lot that's been put in the file recently, so it'll take me a minute to pull out the right documents and read through that. But if I could have... well, let me ask you, Mr. Bishop, I know you have filed the motion requesting that the guardian be removed. So my expectation is that you are objecting to Ms. Wolferts' request that the guardian be appointed in this case. Is that fair to say?
Yes, Your Honor.
Well, what I'll do is I will direct you both to prepare a proposed order, either approving or denying the appointment of the guardian. I'll look through what I've got here in the file, and then I'll choose which order I'm going to sign. That way we can get that taken care of quickly.
Thank you, Your Honor.
Okay.
Do we need anything?
Thank you, Your Honor.
Yes?
Again, I don't believe I've been included on all of the information that's being sent to the court or being filed. If the attorneys could just please make sure that I'm included, that would help.
Yes, and Sandra, I'm sorry I haven't done that, but I will do that today.
All right, thank you.
Yeah, no problem. I will. Do you get the green filing, Sandra?
Yes.
Okay.
But, I haven't seen journals. I haven't seen, a lot of the contacts and information that maybe has not been filed on the green filing.
Okay.
And I'm happy to talk to either of you at any time.
I'll give you a call after we've had a chance to hang up.
But you'll have to call my home number because like I said, we're about to get on a plane. If you could send me that would be great.
Sandra, can you give me a number where you can be reached?
We're on the record right now, so
Okay.
You may want to exchange that off when we
Information
get off
later.
the record. I know Ms. Dredge gave her number on the record yesterday, and I did ask the clerk to see if we could take care of that so that that's not on the record. But
Okay, that'd be great.
Send me an email. I could respond to that, and my email address is sandra@dredgelaw.com.
Okay.
So you could have Utah Family Law TV calling you at home, Sandra.
That's a big part of it.
Yeah, unfortunately, huh?
Yeah.
all right, do we need anything else for this morning, then?
No, I don't think so, Your Honor.
so.
Thank you very much for your time.
All right, thank you, and we'll stay in touch, I'm sure. All right.
Thank
Thank
you,
you,
Your
Judge.
Honor.
All right, thank you. Bye-bye.
Bye.